Good evening, ladies and gentlemen. Good evening to my colleagues. Thank you so much for tuning in again to a Clinix Health Group webinar that is held every Thursday. And it's been the case since COVID times. And because of the interest and the ongoing demand, it has been our pleasure to present these webinars on a Thursday evening. We know that it is sponsored by the Clinix Health Group, and we certainly want to say thank you to the Clinix Health Group for continuing their support in terms of ensuring that we as colleagues, or at least parties inside of the health sector in South Africa, continue to have a platform where we can learn from each other. We can share ideas, we can have different concepts that we will put on the table. Sometimes they are differing in nature, but this is why we are able to learn and understand. And we look at it from various sectors, various angles. As you know, we cover topics from what is happening, for instance, in the political health sphere. When we had the Minister of Health who presented to us in the beginning of the year, so he gave us an idea of what is coming forward as far as the NHI is concerned, and some of the adjustments and changes. And I'm sure you noticed there were certain headlines that were in the media, and that will continue to expand as people are truly vested in what is going to happen as far as the NHI is concerned. We will be inviting other speakers, not only from a political point of view or from a ministerial point of view, as we had the minister, but also other parties from the private sector representing doctors that you are possibly registered with, and then also from independent organizations, so we can understand how the nuances will come into play and how everything will intersect as time unfolds. And you can be prepared as healthcare practitioners and those who have a great interest in the health sector within the South African environment. So we will most certainly be providing that. Then we've had a number of speakers from a nursing perspective who have come forward, and great presentation from them. We also had speakers that presented on subjects such as ethics. So we're certainly looking forward to next week's presentation by Professor Judith Bruce, who will be discussing ethics matters for us. And I think we all need CPD points as far as ethics is concerned. So we will be having those discussions. But tonight, in particular, we have the return of a very senior gentleman by the name of Bryce Perrett. He's joined by his colleague Mishka Maharaj, and they both based out in Durban. It's quite warm over there, I understand. And everybody, all the school kids are complaining that they have to wear blazers because it's still quite hot over there in Durban. We are calling you from Johannesburg this evening, and we just wanted to say thank you so much for all of you making time this evening and spending it with us. I don't know if you're having your dinner, you're spending time with your family, but this is certainly a great platform where we continue to meet every Thursday. And so the discussion today will be from a legal angle. We had so many questions and queries that were put forward to Bryce the last time around. And as you can see, this evening's conversation is compensation and damages in medical legal claims. And so he brought back up, as you can see with Ms. Maharaj, and so she will be assisting us. So just for the sake of housekeeping, please remember that we will be disabling your videos and your audios, and that you can ask questions in the chat while the presentation is unfolding. And they are presenting on that subject. If there's something that catches your eye or you would like addressed towards the end of the presentation, we will raise that as a question or query. And because they're so brilliant and they're so knowledgeable, they will be able to answer all of those questions, especially the difficult ones that Mishka joined us for this evening. And then if you want to ask a question directly, please just feel free to raise your hand. And Tolakela, who is in the background, as well as Neo Poshoko, so they are in the background, and we will unmute your microphone or your video if that's what you choose, and you may ask the question directly to the presenters this evening. So about the presenters, we just want to say thank you again, Bryce, that you are here with us. And yeah, thank you so much for acknowledging your gift and flouting it, letting everybody see what it is that you got. And this is why Mishka's here, I'm sure, this evening. Uh, for those of you that may remember, Bryce Perrett is actually an attorney and he's a director of the law firm Donays. Just for sake of clarity, the last time that he was on here, Denise was not Denise. They had a name change. They used to be called Norton Rose Fulbright. It's part of the international body, but because of the South African entity, they then were ring fenced and they decided to go independent. Bryce, you can obviously clarify that if I'm saying anything incorrectly. And so now they have changed their name as the South African operation. Nothing has changed. They still the same consummate professionals, and they still continue to support all the doctors and the various clients that they have. And they have not lost any of their staffing or anything of that nature that will impact the services that they render. And so just wanted to say thank you to them for joining us here this evening. So Norton Rose Fulbright, Denise today. So Bryce, again, as I said, he's a director of this law firm, Denise, and he's a member of its medical law team. He's based out in Durban and is also a member of Denise's medical team. He represents and he assists various private hospital groups and also in the provincial departments of health. He assists private healthcare practitioners and private healthcare sector insurance in litigation as well as regulatory matters. You'll hear when Bryce speaks, he speaks like a doctor because he gets exposure to so many of these different topics and items, and it's quite impressive. And he also assists with in dealing with clinical risk matters that we sometimes approach him for. Then we've got Mishka Maharaj, and Mishka is an attorney, and she's an associate of the law firm Donays, and she's also based out in Durban. And as a member of the medical law team there, Mishka herself focuses on medical malpractice, professional indemnities, and public liability and personal injury claims. Mishka, that's a lot. And she represents clients in insurance litigation, and has also got quite a significant amount of years in experience in medical negligence matters, including cerebral palsy and post-operative injuries. So those are quite common cases that do present in this space. So Mishka certainly has the experience and will be able to assist anybody that has a specific need. So thank you very much for everybody joining this evening. Please remember, if someone sent you the link to click on and register, you will receive your CPD points or your SANG points or the like. But if you had a link that you just clicked on and it brought you to this presentation, it most likely won't get your points. So please make sure that you get the link that registers and ask for your name and your number for the organization, like the NP number, for instance, or your SANC number, and we'll be able to forward you your points. So thank you so very much, Bryce, Mishka. We look forward to your presentation. Our colleagues are all online. So far already, I think there's over 500 people here, all looking forward to your presentation. My colleagues, thank you once more for joining us this evening. And Bryce and Mishka, over to you. Thank you.
Thanks, Dr. Shinners. I hope that there aren't any of you that saw a different name, Denise, rather than Norton Rose Fulbright and thought it would be someone else and that you wouldn't be listening to me again after our last chat. I think it was back in October. But for those of you that thought it was someone different, I'm afraid it's me again. Thank you, Dr. Shinners, for the introduction. And I'm not going to be trying to talk like a doctor today. I'm going to be sticking with what I know as a lawyer. And the topic that we're going to be focusing on this evening is the compensation and damages in medico-legal claims. So just briefly, in terms of a bit of background before I hand over to Mishka to get going in terms of the overall background to what we're going to be talking about today. Many of you, if you have been involved in litigation matters, or perhaps have had in personal capacities or otherwise interactions with the courts, when one is sued in a civil claim, so if you as a doctor, a hospital group, or a healthcare practitioner have an incident of medical negligence and the patient decides to institute an action to claim damages, there's typically two phases that it would go through. The first is liability. So the question on liability is, can you be held responsible in law for what transpired? So there's various questions under that, and I believe members of our team have spoken on this platform before about it. But once the question of liability is dealt with, so can you be held legally responsible for what happened when something went wrong? The next question then is, what are the consequences of that damage in terms of the harm suffered by the plaintiff or the patient in question? And then what is the monetary value that is attached to that? And both questions, liability and quantum, are complex and have their nuances and particular challenges and pitfalls even that one has to overcome and manage and deal with as part of the litigation process. And what we're going to be chatting to you about today is specifically the quantum leg of things. And so that is, how does compensation work and are damages provided for in the context of medico-legal claims? And within that, the focus that we're going to be giving today is to a very recent decision of the Supreme Court of Appeal, TN on behalf of BN versus the MEC for Health Eastern Cape, and what that means for a new area, if I can put it that way, of the law around a novel approach to compensating damages, particularly in medico-legal claims. So with that bit of an introduction, I'm going to hand over to Mishka to set the scene in terms of what the position is in terms of our law before I pick up and deal with what's transpired in this case of TN on behalf of BN. And I did ask Mishka to deal with this, but since I'm there, I'll deal with it. That the initials that you see in the cases that we're going to be dealing with today, for example, the one on screen, TN OBO BN, means TN on behalf of BN. And those initials are an anonymization to protect the identities of minor children that are involved in these cases. So that's a bit of an explanation. So when you stare at the citations of the cases on screen, you're not confused as to exactly what on earth TN OBO BN is. With that, Mishka, I'll hand over to you.
Thank you, Bryce. Hi, everyone. So I'm going to take you through a few of our principles in the law of delict in South Africa, which govern how relief is awarded to plaintiffs. So I'm going to take you through the foundation of these principles and explore how recent developments in medical negligence cases are beginning to test the limits of these principles, using a few case examples. So I think the best place to start would be the current way. So the current legal position in South Africa. At the moment, when it comes to compensating successful plaintiffs in medical legal claims, there are three rules in our common law that our courts look to. The first is the once and for all rule. The second is the rule that damages must be made in a lump sum payment. And the last rule is that an award must be sound in money. So I think we can start with the once and for all rule first. So if you put it another way, the once and for all rule simply means that a plaintiff must claim all damages, so past, present, and future, arising from a single cause of action in one action or claim. So you can't institute another claim further down the line for additional losses arising from the same wrongful act. So to give you a practical example, let's take a person who was injured in a car accident. So let's say that they instituted a claim for damages and claimed their medical expenses at the time of the accident. If 2 years later, their injury worsens and they require additional surgery or long-term care, in terms of the once and for all rule, they can't actually bring a new claim for these additional medical expenses. So in other words, they should have catered for future medical expenses when they instituted their initial action. So why does this matter? For plaintiffs, it matters that because it means that they need to think ahead and consider everything in their claim, even uncertain future costs. Additionally, when claiming for these future costs, they have to properly justify their claim, have experts accommodate for these contingencies when they make their recommendations, which can be difficult. For defendants, it ensures finality, so it means you won't face repeated lawsuits arising from the same incident for years on end. It means your liability will be settled once and for all. For courts, however, it requires a judge to estimate future damages, sometimes decades into the future, which can be very speculative and difficult for them. So we deal with a lot of cases where future damages are an issue, and we tend to see it the most in cases involving children who develop cerebral palsy as a result of medical negligence during labor and delivery. So because of the nature of these children's conditions, in every single one of these cases, parents claim for future medical expenses. So think of caregiving, special schooling, future medical or surgical intervention, and so forth. They also claim for future loss of earnings on the basis that these children will likely never be capable of entering the job market because of their condition. So the once and for all rule is a principle that is sound, rational, and has stood the test of time. The next rule that we deal with in our common law is the lump sum payment rule. So when we talk about the lump sum payment rule, it's very closely linked to the once and for all rule, and often the two are conflated. Some say that the lump sum payment rule is more of a consequence of the once and for all rule rather than a standalone principle, but it remains well entrenched in our law as its own principle. So the lump sum payment rule essentially means that when damages are awarded to a plaintiff, it must be paid out in a single lump sum rather than in installments or ongoing payments. And it makes sense when you look at it from the perspective of if all claims must be brought at once, then all awards should be made at once. But there are advantages and disadvantages. So on one hand, a lump sum payment means that a plaintiff knows exactly what they're entitled to. The defendant discharges his liability once and for all, and courts are not burdened with the responsibility of supervising ongoing payments for years and years. But on the other hand, a plaintiff may spend money too quickly or invest poorly. Courts are now forced to predict future costs decades ahead of time, and factors like inflation, new medical treatment, or worsening conditions can make a lump sum payment inadequate as time passes. But in South Africa, our courts have traditionally stuck to the lump sum payment rule. However, recent cases have begun to question whether this rigid approach actually serves justice. And then lastly, our last rule is the monetary relief rule. So this is the rule that an award must be sound in money, which simply means that when a court awards damages in favor of a plaintiff, those damages must be expressed in monetary terms. So not in services or goods or other forms of compensation. Now, this is quite interesting because the case that apparently lays the foundation for this rule is a lot more interesting than it's given credit for. So with that, allow me to take you back to 1863 when a bricklayer named Eckstein fought with a railway company. So in 1863, there was certain legislation that was passed which essentially allowed for a railway company to expropriate land and offer compensation in return. So if the compensation was disputed, then the dispute would be automatically referred to an arbitrator. So in this case, Eckstein, who was a bricklayer, disputed an offer of compensation made to him by a railway company. And the arbitrator had decided that the railway company should compensate him partly in money, £350 to be exact, and partly in kind in the form of excavation and deposit of valuable brick clay near his pug mill. Now, Eckstein wasn't too thrilled with this because he really just wanted the money. So the matter came before Judge Bell of the Supreme Court of the Cape of Good Hope, who considered whether his award was appropriate. And it was Judge Bell who famously stated that when damages are due by law, they are to be awarded in money because money is the measure of all things. But, and this is the part that people tend to leave out, Judge Bell immediately qualified this by saying, but that proposition may fail in its application according to the particular circumstances of the case to which its application is directed. So in short, Judge Bell found that the arbitrator's award was inappropriate, but for a very specific reason. So he only found the award to be inappropriate because the wording of the legislation at the time provided that compensation was to be paid, which he interpreted to mean monetary compensation specifically. But he was actually convinced that the award itself was eminently reasonable, which shows us that compensation in kind was not off the table even back then. So now that I've covered the three principles, we can look at some recent case law and the direction in which our law seems to be heading when it comes to compensation and damages in medico-legal claims. So the first case I would like to discuss is the case of Ngubane versus South African Transport Services. So in this case, the plaintiff was a daily user of a passenger rail service owned and administered by the South African Transport Services, who is the defendant in this matter. So every day, the plaintiff would board at Dubé Station and proceed to Cleveland Station, where he would get off and go to work. But in between Dubé Station and Cleveland Station, there were two other intermediate stops along his route to work. One of them was Grosvenor Halt Station. So one morning in 1985, the plaintiff boarded a full train at Grosvenor Halt Station to get to Cleveland Station and go to work. Unfortunately, the train was quite full on this day, so when he got onto the train, he boarded it but had no space to stand other than very close to the train's doors with his back facing the door. He had held onto one of the straps on the overhead railings of the train. But when the train started to move, because of the rush of people getting on and off the train, he actually fell backwards through the open doors of the train and landed on the tracks between the platform and the train, somewhere underneath the train. And he obviously was injured. So he sued the South African Transport Services for his injuries on the basis that the rail service was negligent for, firstly, allowing too many passengers on the train, and secondly, for allowing the train to start moving when the doors were not properly closed and it wasn't safe to do so. So the court found that the negligence of the rail service was the cause of the accident, which was the cause of his injuries, which included upper limb weakness and difficulty walking. So when he instituted his claim, the plaintiff claimed future medical expenses on the basis that he would use private medical practitioners and private hospitals. So South African Transport Services, the defendant, argued that the same services were available at state or provincial hospitals free of charge. The court considered the argument and found that once the plaintiff had led his evidence that of his anticipated future medical expenses, the defendant would then be entitled to lead evidence that the services of the same standard could be acquired elsewhere at a cheaper rate. So the court emphasized that it wasn't a departure from the established common law principles that I told you about, but that it was an assessment of what is reasonable in the circumstances. So in other words, damages need to reflect what's reasonable and not necessarily the plaintiff's preference for private care. Unfortunately, the defendant was unsuccessful in proving that services of the same standard as the private sector were available at a cheaper rate in the state sector. But this case is still important because it opened the door to this idea of alternative relief without changing the status quo. So now we move on to the case of DZ on behalf of WZ. So this case took place almost 30 years after Ngubane, and the Constitutional Court was confronted with a case that required them to now consider the lump sum payment rule, which we talked about earlier. So in this case, DZ had given birth to her child at the Chris Hani Bargwanath Hospital on the 19th of November 2009. And unfortunately, during labor, the child suffered asphyxia as a result of the hospital's failure to timeously perform a C-section. And as a result, the child developed cerebral palsy. So the Department of Health accepted that the child's condition was caused by the negligence of the hospital staff, and it conceded liability in the sum of 23 million rand, of which almost 20 million rand was in respect to future medical expenses. So the Department of Health delivered an amended plea before the High Court, where it indicated that it wanted to satisfy this award for future medical expenses by undertaking to pay service providers directly for the child's future medical expenses, as and when they arise, within 30 days of presentation of a written quotation. So this would be instead of paying 20 million upfront in one go. So the department's argument was that the common law allowed it to do that, and if it didn't allow it to do that, then it should be developed to allow for payment as and when expenses arise. So this matter eventually went to the Supreme Court of Appeal, who found that the once and for all rule at common law actually prevents a defendant from satisfying an award for future medical expenses the way that the Department of Health was trying to do. And it declined to develop the common law on the grounds that there was no evidence to suggest that this development was necessary to promote the spirit and objects of the Constitution or the Bill of Rights. The matter then went to the Constitutional Court, who ultimately confirmed the existing common law. So damages must be sound in money, made in lump sum, payment, and once and for all. So in the majority judgment penned by Frontman J, it was held that it would be inappropriate for the common law to be developed in this case because the department failed to produce sufficient evidence to justify development. However, the possibility for future development of the common law where a defendant does produce sufficient evidence wasn't excluded. Additionally, the Constitutional Court reaffirmed what was said in Ngubane, which was the case we just discussed, which was that the defendants who wish to dispute a claim for future medical expenses are entitled to produce evidence to show that it would be reasonable for a plaintiff to obtain less expensive medical services at, for example, a state hospital. Interestingly, Jafta J concurred with Frontman J's judgment, but for very different reasons. He actually said that the common law does not prohibit periodic payments of delictual damages. Instead, he says that the once and for all rule serves to regulate the judicial process by ensuring that a claimant sues for all of his damages arising from one cause of action in one action. So this is simply to avoid several lawsuits and to ensure that there is an end to litigation. Once again, in this case, the status quo remained, but the door for change was kept open. This now brings us to the case of MSM, which took place a couple of years later in the Gauteng High Court, which was confronted with the possible development of the monetary relief rule, so the rule that damages must be sound in money. In this case, MSM sued the Department of Health for damages arising from a neurological injury sustained by her child during her birth on the 25th of June 2012, as a result of which she ended up developing cerebral palsy. So in this case, the department conceded liability for 60% of the plaintiff's proven damages, but the department sought to lead extensive evidence on what services could be provided instead of monetary payment for the child's future medical expenses. So in this case, the department proposed that many of the child's future medical needs could be provided at a public hospital in Johannesburg at the same standard or even at a better standard than the private sector. So after hearing detailed evidence from hospital management and a range of specialists and experts, the court found that the department had actually produced sufficient evidence that the identified services were available at a public hospital at a comparable or better standard. So it was on that basis that the Gauteng High Court took a big step and developed the common law. So the rule that delictual damages must be sound in money was now developed to permit a court order to allow for compensation in kind in appropriate cases, more specifically where the department is liable for negligence that caused cerebral palsy in a public hospital, and where the department establishes that equivalent or better medical services are available in the public sector, either at no cost or at a cost that's lower than what is being claimed by the plaintiff. So granted, it's an extremely narrow and qualified development of the common law, but it was an express development of the common law nevertheless. So on that note, I will hand over to Bryce, who will take us through the Supreme Court of Appeals decision in TN and what the future may hold.
So the MSM case was a big step towards a new way or proposed new way of compensating for future medical expenses, particularly in the context of medico-legal claims. And the decision that we're primarily going to be, or the matter that we're primarily going to be looking at this evening, was a case down in the Eastern Cape, TN on behalf of BN versus the MEC for Health Eastern Cape, where a minor child was born in a public hospital, and as a result of negligence in the course of his mother's labor and his delivery at that public hospital, he sustained a brain injury and ultimately developed cerebral palsy. And his mother brought an action in her personal and representative capacities on his behalf for claiming damages in the tens of millions, of which a significant portion related to future medical expenses. And the MEC, in response, raised two remedies. It termed the overall defense's remedies, and the first of them was the public healthcare remedy, and that aligned largely with what was done in MSM around being focused on the provision of services in the public healthcare sector. And what the argument that was advanced by the MEC there was that the services, equipment, medication, etc., that this minor child required for his condition, cerebral palsy, could be met and provided for in the public healthcare sector at a reasonable standard. And so it was not necessary or reasonable for the child to receive compensation in money instead for the provision of those services in the private healthcare sector. And what was different about this case when compared to the MSM case that Mishka's just discussed is that it went a step further. And instead of just providing for compensation in kind, so that's what Mishka has explained as the provision of services, equipment, medication, instead of paying out in lump sum for it. What went beyond it in this particular case in the Eastern Cape was that there was a fallback position, and that was the undertaking to pay remedy or undertaking to pay in future remedy. And what that entailed and was sought by the MEC or the Department of Health there was that in the event that particular services, equipment, medication, and the like weren't available at a reasonable standard in the public healthcare sector or weren't available at all in the public healthcare sector, then at the Department of Health selection, they could either procure that equipment, that service, that medication in the private sector itself, or they could reimburse the plaintiff or a trust established to assist and represent the minor for those costs for medical services, treatment, equipment, etc., as and when those expenses were incurred. And that was a significant step beyond what had already been dealt with in the MSM case. The case in TN at the Eastern Cape Division was supported by evidence from the head of department, evidence from Treasury, evidence from finance within the Department of Health in the Eastern Cape, as well as clinicians at two state hospitals and independent experts, including expert economists dealing with how this system might work and whether or not it was viable within the Eastern Cape Department of Health. Ultimately, the court found in dealing with the once and for all rule and the rule that compensation must sound in money, that those weren't the only and predominant rules in terms of the common law for compensation. And in fact, there was scope within the common law to allow for a development of the common law to provide for compensation in kind and this undertaking to pay remedy. And the court was further satisfied that the services were available to the child at a reasonable standard, and failing that the undertaking to pay remedy would step into the breach and provide for those needs that couldn't be provided at a reasonable standard within the public healthcare sector, rather than a lump sum payment up front. And that decision obviously constituted a significant shift in the way damages are compensated, bearing in mind the traditional position in terms of a claim being brought once and for all, and that it needed to be paid in lump sum in money. And to give an idea of the shift in terms of the position in terms of the once and for all rule, how the undertaking to pay in future remedy was structured was that a private case manager would be appointed to represent the trust that administered or acted in the child's interests, and then a public case manager would be appointed. And annually, what was required of those case managers was to meet and decide a management plan for that year for the minor child. And that would include whatever therapy, medical treatment, medication, equipment, etc., that this child would require over that period, and reach an agreement as to that and a general costing, so that there would be a plan in place in terms of accessing the services in the public sector, and to the extent that the services couldn't be accessed, procuring them or reimbursing for them in the private healthcare sector. And if agreement couldn't be reached on that management plan, what would then happen would be the matter would have to go to mediation. So there'd be a mandatory mediation process through which those differences or disputes would be sought to be finalized. And if that failed, what the parties could then do was approach the court again for an order as to what was required or reasonably required for the minor child and the way forward. So you had a system in place where there was an initial step in terms of the case managers engaging to agree a plan for treatment. Then, failing that, a mandatory mediation process to try and resolve any differences that arose. And failing that, if there was still a dispute, that would then go back to the courts. And that was a significant shift from what Mishka's explained about a single action, a single award, and finality. What this meant was that there remained the possibility of the dispute ending up back in court if there was a disagreement around the undertaking to pay remedy, and in fact the public healthcare remedy, where there was an issue around whether or not services were being provided at a reasonable standard. So perhaps not surprisingly, given the significant shift and the fact that the impact of the judgment was to reduce the claim amount, the monetary claim amount on the part of the plaintiff quite significantly, the matter went on appeal to the Supreme Court of Appeal. And the decision of the Supreme Court of Appeal was handed down recently on the 11th of February 2026, and has had a significant impact on this proposed new way in terms of compensating damages in a way different to once and for all and in lump sum. And what the Supreme Court of Appeal said in its judgment was that the effect of the decision in the Eastern Cape in the TN on behalf of BN case was such that it had abolished the once and for all rule and the rule that compensation must sound in money. And in dealing with whether or not that was appropriate, the court stressed the importance of the rules, the once and for all rule, and the rule that compensation must be in lump sum. And ultimately, the Supreme Court of Appeal decided that whilst those rules may be imperfect and subject to criticism in some respects, which Mishka has outlined, what they serve to do is provide certainty and finality. And that outweighed the interest in terms of the development of the common law, and the door that it opened by providing for compensation in kind or for the undertaking to pay remedy. And what the court said there was that the system that was put forward in TN on behalf of BN in terms of the dispute resolution mechanism was such that you would have interminable litigation. Every time there was a dispute, or there would be a dispute around the reasonableness of care in the public sector, or in fact a dispute around the management plan, for example, under the undertaking to pay component, that had the potential to come back to court, amount in further litigation, and what the courts, according to the Supreme Court of Appeal, would be left as would be administrators of a public healthcare system rather than adjudicators of disputes. And that links to the next important thing that the Supreme Court of Appeal said, and that is that the development of the common law in this area should be left to the legislature. And in this context, there are already pieces of legislation in foreign jurisdictions that allow for compensation schemes such as this. Even in South Africa, we've got the Road Accident Fund, which in a similar way has sought to regulate compensation in the context of persons who have been injured in the course of a motor vehicle accident. So what the court said was that sort of change, fundamental change to the common law, should be left to the legislature. And the reasons that the court gave for this in particular is that there are wide-ranging socio-economic implications to allowing this defense to proceed. And one of them, for example, is that, as Mishka mentioned in the MSM case, in TN, the court specifically said that the development of the common law was limited to children suffering an injury as a result of negligence in a public hospital, and to compensation in kind being provided through the public healthcare sector. And that narrow band, or the way that the court sought to frame it in the Eastern Cape, meant that children in the public sector were impacted by this defense, but children born in the private sector were not. And that question gave rise to issues of equality or inequality that perhaps were far-reaching and required rather a politically appointed or a commonly elected official or a body such as the legislature to deal with and to make a determination, in fact, on whether or not that was desirable. The other issue that the court raised was this decision was out of the Eastern Cape. There was the MSM decision in Gauteng, but there was a conflicting decision in KwaZulu-Natal, which had said that the development of the common law rules of once and for all and lump sum compensation should be left to the legislature. And what the court said is this type of development needs to be of broad application. So it needs to apply to all persons, not to a specific category by its very nature, and it needs to apply nationally. So you can't have a situation where in certain provinces you can compensate in kind, but in other provinces you can't. And for that reason, amongst others, the court said that it was best left to the legislature to make this sort of development to the common law position. Another final thing that the court touched on in dealing with the judgment on appeal is the level of evidence required. And I touch on it now just before we move on to the next section about what the implications of the judgment are to illustrate a point. And the point that the court made was that what is required in this context is to demonstrate that a service is sustainable. So the service and the provision of compensation in this way is sustainable. And in a case like TN on behalf of BN, you're talking about a minor child with a life expectancy of 15 to 20 years. And you need to be able to demonstrate as a defendant wishing to rely on the remedies of compensation in kind and an undertaking to pay, that firstly, for the duration of that child's life expectancy, you as a defendant will be able to provide the services, equipment, medication, and the like required by the minor child at a reasonable standard. And if that were not to be the case, then of course the defense would fail, because if you're not able to do it, then you would fall back to the position around compensation and money to allow the plaintiff or the minor child to procure services into the future as and when required. And then secondly, in terms of the undertaking to pay remedy, one would need to demonstrate the financial capability and capacity on an ongoing basis to be able to provide for the minor child's future medical and related expenses. And in this context, the court said the evidence that had been led, the Supreme Court of Appeal said that the evidence that had been led in the Eastern Cape demonstrated that funding had been budgeted for the defense, particularly the undertaking to pay remedy, for a period of 2 years, but not beyond that. And there was also, according to the Supreme Court of Appeal, insufficient evidence led as to the sustainability of the service in terms of the compensation or provision of services in the public sector rather than payment for services in the private sector. And for that reason, the Supreme Court of Appeal said that the evidentiary standard that was required to be met in terms of demonstrating the sustainability of the undertaking to pay system and of the sustainability of the delivery of services in the public sector hadn't been met. So ultimately, what the impact of the Supreme Court of Appeal decision is is to reverse the position as it had been after the Eastern Cape decision in TN on behalf of BN. But, and I'm going to touch on it in further detail now, it is subject to a further appeal by the MEC to the Constitutional Court. So Mishka and I have spoken like lawyers for a lot this evening, and what are the implications of what we've discussed for you, as I understand it, primarily persons involved in the private healthcare sector? And as we've both spoken about, the cases MSM and TN, where the development of the common law was allowed to provide for provision of services rather than payment for future medical services in lump sum, and the undertaking to pay remedy in the Eastern Cape. What those developments were limited in those cases to specifically children born in the public healthcare sector, and the provision of services and the compensation through an undertaking to pay in the public healthcare sector, and specifically those departments of health, the Gauteng Department and the Eastern Cape Department of Health. So the judgments couldn't be relied upon if you were a private hospital group, you couldn't take that judgment to court and say, hang on, the common law has been developed to allow us as a private hospital group to provide services in kind instead of paying out future medical expenses for this particular plaintiff. Or as a corporate entity, we will provide an undertaking to pay as and when this individual plaintiff requires future medical services, equipment, or medication. So those judgments didn't allow one to do that, but they opened the door to the possibility of arguing for it as a private entity, a private hospital group, a private healthcare practitioner. The challenges there, and I am talking a bit in theory because, as I've said, the decision is going on appeal to the Constitutional Court, and we'll have to see what happens with that. But the particular thrust of the argument for the development of the common law in the public healthcare sector was the fact that the public healthcare sector is faced with an overwhelming number of medical negligence claims with huge, in the billions of contingent liability, and the impact that has on the provision of healthcare for all under the department's constitutional mandates. And that argument is a lot stronger, I would suggest, than a private hospital group, for example, saying, our shareholders are unhappy that we're having to pay these claims, so we want to provide the services in kind. So there's a bit more weight, arguably, in the public policy considerations. However, we have dealt with a number of cases where there's been settlements achieved whereby there's been an agreement in the private healthcare sector to provide services or to reimburse or to compensate in the context of settlements. And that's quite an interesting area that is perhaps worth exploring, is to provide, for example, for the costs of a hospital admission to remedy a particular issue that a plaintiff might have as a result of an incident of negligence within a private hospital setting, for example, or even a private practitioner, if they can arrange a colleague to assist at a lesser cost than one would typically pay, then perhaps that's a route that might be open to one to pursue. But again, that's premised on the plaintiff or the patient agreeing to that sort of thing. And if one were to argue it at court, you might well face some challenges. Practically too, and I spoke about the evidentiary component to the Supreme Court of Appeals decision and what is required to be demonstrated. And there, the big thing to bear in mind from a private sector perspective is that you need to be, if you're talking about services over a prolonged period, so if you're talking about, for example, a child with cerebral palsy who's going to require care for a life expectancy up to age 48 or 50, and they're currently age 7, you need to be able to show and provide evidence as a private practitioner or a private hospital group, for example, that you will be able to provide that service or provide for the needs of that child for the rest of that child's life. And where you're talking about a private entity where, you know, the financial performance may change, there may be restructuring, there may be a change in footprint in operations, etc. Those are challenging evidentiary questions to answer. Alternative approaches that might be of interest from the private healthcare sector. I've spoken about settlements and the possibility for arrangements where expenses are compensated as and when they are incurred, or where particular services are provided for free in lieu of paying them out in lump sum. Another interesting possibility is there are two of the departments of health that are attempting to run the public healthcare defense on the basis of the Ingobane case that Mishka discussed right at the beginning of the talk. And the Ingobane case, just to not go into full detail on it again, but to just touch on the important points there. The Ingobane case said that what was required to succeed with this type of a defense, so provision of services or compensation in kind rather than paying out in lump sum, was to demonstrate that the services or medical needs could be met at the same standard as the private healthcare sector or at an acceptably high standard. And if potentially the departments that are pursuing those defenses were to succeed, that's not a development of the common law per se. What that is the normal common law position of, I want to pay this amount to see this doctor as the plaintiff, and me as the defendant saying, no, that doctor's too expensive. You can get the same care for half the cost with this doctor. And so it's unreasonable for you then to be paid double the amount to see the doctor that you want to go and see. Those are the normal principles that we deal with in the legal sphere on quantum, you know, every day and routinely, and that's been the position for time and memoriam. But if you have a situation now where there's a decision in favor of one of the departments in a particular province that says, actually, this person who requires this particular type of orthopedic care can receive that care for free or at a lesser cost in the public sector. So I'm not making an award in money for the same thing to be done in the private sector. Then arguably as a private defendant, one may be able to argue and say, well, the courts found in this case that this particular type of procedure can be done at the same standard or at an acceptably high standard in the public sector. We shouldn't have to pay for it in the private sector. So that's an interesting space, perhaps the next step in the process of this defense. And if that angle succeeds, then there might be more scope to rely on it from the private healthcare sector perspective. Then to close, as I've said, the TN case is on its way in terms of an appeal to the Constitutional Court. The Eastern Cape Department of Health, or the MEC, applied for leave to appeal to the Constitutional Court in the beginning of March. And the plaintiff side, so TN, has not opposed leave to appeal, and the parties have requested an expedited hearing date for the appeal to the Constitutional Court. So the hope is that that will be dealt with sooner rather than later. And ultimately, we are going to have to wait to see whether or not the Constitutional Court allows the court development that has been initiated by the court in the Eastern Cape, or decides that at the end of the day, the once and for all rule and the rule that payments must sound and money are paramount, and the legislature should be left to deal with this sort of thing. And that concludes our chat this evening. It's been wonderful to go through all of that with you. I didn't say thanks in the beginning to Clinix for the opportunity, so I do so now, and I look forward to hearing any questions.
Bryce, you and Mishka, I knew that it's going to be, informative and very insightful, and it certainly is. And while you were speaking, quite a number of questions were posted in the chats, and we will certainly go through all of those. I hope I'm audible and clear enough, and you're able to hear me. So I really would like to thank you so much for taking the time and studying the cases and really giving us a sense of your comfort and your knowledge and experience with how you deal with these matters on a daily basis. So we're really looking forward to asking you all sorts of complicated questions, which you're going to answer. So the first one is, won't you please, for the colleagues that joined a little bit later than when you started, the what all those abbreviations mean on behalf of and so on, and because of the age and certain nuances related to that. Thank you.
Mishka, you want to kick it off?
Oh, so the abbreviations in the case names. So you would have noticed that a lot of the cases that we spoke about, like DZ, MSM, TN, those are actually the names of the minor child and the minor child's parent who would be suing on behalf of the minor child. The reason that it's done in initials is just to keep the identity of the minor child and their parents anonymous, during these legal proceedings.
Yeah, I just wanted to get some clarity on that. And for those of you that can see on your slide at the moment, I told you, Mishka, there are going to be lots of appreciation notes going up. I think you're getting more than Bryce got the last time when he was here. So thank you so much for joining with him. Yeah, so if we could, yeah, I told you, right? For those of you who can see on your screens and you see that it says Danae's, Danae's previously was known as the Norton Rose Fulbright firm. They are a law firm, and the two colleagues that are here online, they're actually based out in Durban rather, and they have offices in different parts of the country. And so they've separated themselves from the international Norton Rose Fulbright, and we have a different name to them. So that's who this is joining us this evening. So let's go straight into some of the questions. I see that Dr. Leslie Ramia, I know there's also an Apostle Leslie Ramia, so I don't know who, maybe it's both. There's a question here. It talks about how life expectancy is determined in children with cerebral palsy, and what is it based on? I know that at some stage, Bryce, we were talking a lot about this. It's quite a common occurrence, and I know in your firm you also have a division or a section that works out what the costs are. I think maybe just before you even get into that, some people will claim 200 million, 500 million, 20 million, 40 million. What informs that claim? And if you can just clarify to them whether it is going to be something that is reasonable, what is not reasonable, and on what determination is made by the courts and how much will actually be payable if somebody is found liable. Thank you.
Thanks, Burton. Yes, another big component in dealing with quantum is life expectancy. And life expectancy, it goes almost without saying, the longer that the plaintiff is expected to live for, the longer one needs to provide for chronic care,
Yeah.
ongoing management, treatment, equipment, and the like. So the bottom line is, if you have a short life expectancy, generally you're going to have a smaller claim. If you have a longer life expectancy, you're going to have a more significant claim. And life expectancy doesn't impact every medico-legal claim, but it's a big part of the assessment of damages, particularly in matters involving children and brain injuries. And how it's dealt with, and I'll deal with perhaps the most complicated one because we deal with it all the time and it's quite litigious or contentious, is the question of life expectancy in children with cerebral palsy. And how it's dealt with there is there's two components. There's a statistical component and there's a clinical component, if I can put it simply, because I can only explain it simply. The clinical component is, what is the child's actual condition? And it's informed to some extent by what one sees in a study that was done in the United States by Strauss and others, where over an extended period, I think it was decades, there was a study done on children with these sorts of conditions of varying degrees of severity. And then those those children were categorized, or categories were reached based on what one saw in terms of the development or challenges faced by those children. And what the experts that we work with seek to do from the clinical perspective is to say, all right, which one of those categories from a clinical perspective does this individual child fit into? And once you reach that, and it's questions like, can the child lift up from prone? Can the child roll? That sort of thing in very severely disabled children. And that puts them in a category, and within that category, then one gets a base level in terms of the deductions or additions on life expectancy. And in the band, there's some adjustments that can be made for degrees of severity. And ultimately, you then use that to plug into a life expectancy table, and the life expectancy table will tell you whether there's a survival time of an additional 18 years, 15 years, 10 years, 5 years. And that's just my very basic lawyer explanation. But it's informed, as I say, by the clinical picture of the particular child, and then the study that was done in the United States, which dealt with life expectancy in this particular population group. And using that, one applies it in a life table to reach a life expectancy. The challenge that we have in South Africa is the study in the States was done in California, and it's using Californian life tables. And I think it goes without saying, and it's uncontroversial, that life expectancies in California differ to life expectancies in South Africa. And we don't have an equivalent study out here. If any of you are interested, please, we'd be very interested to hear from you, because is something that can be challenged, could be investigated, and may well bear fruit in terms of dealing with these cases to fit what we talk about in life expectancy to the South African scenario, rather than having to rely on a Californian American study where there are shortcomings when applying it to our South African context. So that was a long answer, but I hope I got through most of what was asked in that question.
No, we're not in California, you're right. So if damages are awarded, right? I think you spoken to this earlier on, Mishka, that if damages are awarded in a lump sum, can claimant then later return to request additional compensation, medical treatment costs, or other related claims from the same matter, or is it over and done with? I think you did address that quite fully earlier on. I see the question was loaded quite early, so maybe you could just touch base and confirm that. Thanks, Bryce.
Mishka, are you still there? Maybe she's having a technical difficulty. Anyway, I'm happy to deal with it, Burton. Yes, the principle in once and for all, in terms of the once and for all rule, is you've got to claim all of your damages in a single action, and there's no comebacks. Once there's a court order saying that your future medical needs are X and the costs associated with those needs are Y, if your situation changes, you can't come back to the court and say, hey, sorry, it turns out that things are much worse than I expected them to be, and I need more money. You're not able to do that. So that's why it's critical as a plaintiff to get your evidence and your sums right in dealing with quantum, so that there is enough to provide. The argument from the defense side, which is where we act predominantly, if not exclusively, is that, well, it often happens, and you hear stories of it quite frequently, that there's a large award made in one of these brain injury child matters, and you've paid, the Department of Health, for example, pays over 15, 20 million, and within a year or two, the child passes away. And that money doesn't come back to the department. That money goes into the child's deceased estate and out to the family. So, it swings both ways. There is an advantage to finality from a defense side, and that you know it's done, your liability is limited to what that award says. And there's a risk from a plaintiff side in that, well, if that award turns out to be inadequate, you might be left not being able to afford care in the private sector.
Yeah, because I had a question here earlier on, and it's a follow-up question by Nakolo Mtia, who said, what are the implications if the claimant passes away? And what happens to the rest of the compensation that was due to the child? Particularly in the case, I will take it that the care was, or the compensation was in kind. So instead of 20 million being paid out all at once, 3 million is paid out over time. And so there's a 17 million round that would have potentially been paid out, but the person is no longer. What happens in that case?
Yeah, this is also something we didn't touch on it today because it's a whole topic on itself. But um, I haven't acted down there, so I'm not speaking from personal experience, but I understand that the approach that the Western Cape Department of Health has taken is to, rather than compensate in kind or to deal with an undertaking to pay, they have a trust model. So the norm in large awards where there's mental incapacity. So if you have a child who's mental incapacity, an adult, normally what will happen is a trust is created to administer any funds that are awarded to that plaintiff where they are unable to do that. And the Western Cape approach is to say, fine, we'll pay out the lump sum, but into a trust with specific provisions. And that trust has a what's called a top up and a clawback provision. So that means that it works both ways. If it turns out that more money needs to be paid into the trust to provide for the plaintiff's needs, then that's done. But it's against a certificate of depletion that says, listen, yes, the funds have been reasonably expended for the purposes for which the funds were paid out initially. And then the department would top it up. And on the other end of the spectrum, if the plaintiff dies and there's funds remaining in the pot, specifically funds that were allocated for future medical needs, then those funds are then paid back to the department. So that's how the Western Cape's done it. But the position as it currently stands in most of the trusts that are dealt with for these plaintiffs in the country is that upon passing, whatever remains as residual in the trust is paid out to the beneficiaries or to the family as part of the estate process for the minor child's deceased estate.
Yeah, follow-up question by Dr. Ramya. As we're working through the questions, I think those first questions came in, and it's really around whether or not when it's in kind, right? This compensation in kind could potentially be seen as pro bono, but it really isn't, is it? Because at some point, the funding for the additional care is still being provided by the taxpayer through the state, or is it seen in a different light?
So the position in terms of compensation in kind, as dealt with in the MSM case and the TN case that we were primarily discussing, is that there's a court order that specifically says this is what you have to provide. So it's not pro bono, if you know what I mean. You are compelled by a court order to deliver in terms of that order the services, the equipment, the medication. So it's not a kind of a ex gratia approach as it was dealt with in MSM and TN. The order says you are required to provide physiotherapy twice a month for an hour at this facility, So, and likewise, you've got to replace this wheelchair every 2 years. This specific brand of wheelchair needs to be replaced every 2 years. And it isn't a discretion except in limited circumstances that's been built into the order. The requirement is to deliver in terms of the order. So it's not really pro bono, if I can put it that way. It's certainly the position in terms of the cases that we spoke about.
Yeah, yeah, Bryce, and I think the question as a follow-up here, but I think it's Dr. Ibrahim Hafaji saying in responding to Notolo, which is who you spoke to earlier on about somebody passing away prematurely, inevitably there is that eventuality because of the complications that may arise due to the injury that was suffered. And now payment wasn't made in completion. And surely there is a component that goes towards the trauma. As you know, there's always a pain and suffering for the parents because of what transpired. So maybe you want to just touch on that, please.
Yes. No, that's spot on, Burton. The position is that the general damages component. So general damages are damages that are awarded for the intangible things, pain and suffering, trauma, emotional distress, disfigurement, disablement, and the like. That those damages vest with the child. And I think you would really struggle to argue on any basis that that money should come back to the state upon the child's death or the plaintiff's death in a non-child related matter. So like the Western Cape example that I spoke about, as I understand the structure, there are pots. So there's a future there's a medical expenses fund, and then there's a separate fund for general damages and the loss of earnings component of the claim. So the general damages component wouldn't be clawed back and paid out. The general damages would then pass on to the family. But and I just must maybe mention it as an aside and for interest, the burden to prove a claim for emotional trauma and distress isn't to simply come to court and say, oh, I'm emotionally distressed and it's been hard on me and traumatic. You've got to have an identifiable, diagnosed psychiatric or psychological lesion. So you need a psychologist or psychiatrist to say, yes, I've assessed this individual and they have the following psychological issues or challenges as a result of what's happened, PTSD or, the like. And that is on that basis, one would then get general damages for emotional trauma and shock. So I think there's a perception, certainly I think amongst plaintiffs, that you just say, oh, I've suffered emotional trauma and distress. That's not, yes, it is distressing and one might have gone through grief or, deep unpleasantness, but the legal position is you've got to demonstrate an actual psychiatric injury.
So here's a technical question. It says, Babusi Memela says the law of damages is primarily Roman Dutch development of common law. And then how does deferment to legislature assist? And then is it an abdication by the courts of duty? Wouldn't CC assist in such development?
That's spot on. I mean, the once and for all rules and the rule that damages sound and money come to us all the way from the Roman Dutch times. So it's part of the Roman Dutch law. It's also a feature of common law jurisdictions like England, Australia, Canada, and the like. What's interesting is that England has got legislation that provides for a different compensation model in this type of context, as does Australia. So those jurisdictions have already lent on the legislatures to provide a remedy in this particular type of situation. I can't speculate on what's going to happen at the Constitutional Court and whether or not it will follow the Supreme Court of Appeal and say that the matter should go to the legislature, or whether or not it will say, no, listen, this type of development of the common law by the courts is acceptable. I think it is interesting if you look, for example, at the DZ case. So that's that one that Mishka spoke about where it was dealt with in the Supreme Court of Appeal. I think it was a Gauteng matter, then it went to the Supreme Court of Appeal. then the Constitutional Court. And in that matter, at Gauteng, if I recall correctly, the decision of the court was, all right, we can allow for this type of compensation other than once and for all and in lump sum. The Supreme Court of Appeal said pretty much what it said in this most recent case. It said, no, shouldn't develop the common law, and this should be left to the legislature. And then the Constitutional Court said, no, well, you haven't met the requirements for us to develop the common law, but we're not saying that the courts can't if a properly pleaded and evidenced case is brought before the court to do so. So I wonder if that might not be, if a similar angle might not be taken by the Constitutional Court, but that's just pure speculation, and we'll have to see what happens.
So again, yeah, we have Monica Makhai saying excellent presentation. And there's so very many appreciative comments here on the side. So thank you, Bryce. I told you Mishka going to do it. I know Mishka came back on, so I really want to pose more difficult questions for her. The question really is, can you please share in the future when you come back more cases in the private sector? I know the last time some of your colleagues did share some of these cases, but it would be interesting to see actually what happens in the private sector because I know many of these matters are settled prior to court, or what is the approach? If you could maybe just clarify that for everyone. It's not that it doesn't end up in the courts at all, or that there are less litigious cases in the private sector.
Yeah, we've shared, I think, only public sector cases. That was the nature of the topic. But you know, the potential in the private sector is what we were trying to get at. But that potential has been impacted by what's happened with the appeal to the Constitutional Court. So, if that goes, in favor of the department in the Eastern Cape, then might well open the door for more prospective development in the private sector. But as I touched on in terms of practical realities at the end, we deal with a lot of cases where there's arrangements reached on, okay, listen, you can be admitted for this procedure. We'll make an arrangement with this doctor. The doctor will do it, at a discounted rate or for free. So we've dealt with that in the private sector a lot. None of it's been litigated because, as I say, I think the private sector in dealing with this particular defense has more challenges than the public sector to litigate it. But we have dealt with many without prejudice, off the record settlements where this sort of thing has been done. The problem, I think, is the long-term high-value claims, these birth injury cases where you're talking about provision over a decade or more. I haven't had one of those yet where we've been able to settle that sort of a case in the private sector. But if it's a once-off, a remedial laparotomy or something to just deal with a particular issue that requires a single admission, a limited hospital stay, perhaps some rehab and medication, that sort of thing we've dealt with before in the private sector. But again, not at court, only in terms of engagements and settlements. Yeah.
And then the state goes to court with all its cases.
No. Look, we deal with a very small portion of state litigation, a tiny, minuscule portion. Historically, slightly more, but the state attorney would be the one to ask that sort of a question. But our approach, if you're asking about our approach at what was Norton Rose Fulbright, now Denise, if a matter isn't defensible, then we don't want to go to court. We want to settle it favorably. You want to avoid the reputational damage and cost involved in proceeding to court. Rather settle it early if there's a basis to do so. And if there's a strong defense, rather push to have the matter withdrawn. You don't get to court. Get the plaintiff's attorneys to see sense and withdraw the claim as far as that's possible.
Bryce, the Department of Health is one of your clients. So when the gaps were identified by the Constitutional Court, uh, and they were telling the department where all these different gaps are. I'm not saying in the specific matter that you raised, but it's a definite question by Gift Chaka asking, how would you then recommend the department? Will they actually take the advice and adjust their conduct, increase quality of standards, or is it just the same thing, same issues coming up, repeating time and again?
Hi, Gift, firstly.
Yeah.
Uh, and look, it's difficult for me to comment because, we're talking about a client. But all I'll say is that, I don't disagree with whatever the Supreme Court of Appeals said. I've got personal views about it and professional views about it too, that I don't think it would be appropriate for me to express here. But why I pointed to those things was to illustrate what the court says is required to succeed with these types of defenses. The evidence was put up by the department down in the Eastern Cape, and the Supreme Court of Appeals view was ultimately that further evidence or additional evidence was required to succeed. And I know a lot of work went into the case. We weren't involved. But courts have their views, and some of them take a certain angle, some of them take a different angle. But at the end of the day, as practitioners looking at these cases, you can only learn from them and say, all right, well, the court said what their view is in terms of what's required, and the next time we litigate on that basis, we need to plug those gaps. And just as a final comment, the defense as a whole, not so much the undertaking to pay component is less medical, if I can put it that way. There's still a definite medical component, but the provision of services defense, there's a real interface between the law and medicine, and I think it's a tricky line, I think, sometimes to show legal people what the medicine means and medical people what the law is saying. And that is in all medico-legal litigation, there's an element of that. But I think particularly here, there is an area of challenge around dealing with that.
Yeah, so gift, I think in a way it overlaps here, asking about what happens in a scenario where the services are no longer required. The patient recovers, there's some miraculous recovery or otherwise, and then what happens to the rest of the compensation? So that's the one side. I just want to acknowledge Vuisile Gokoma. I see the topic that you're looking for us to have presented around PTSD, especially in the police operations, so and the courts and what the courts are saying at the moment around that. We will most certainly float that and have that someone come and speak to that matter. So thank you for that. And then while that's going on, there's a question from Barbara Ribeiro asking about what's prescription? I'm gonna say subscription. So can a claim be made long after the fact, especially in cases where parents were not aware of their rights? So maybe we can just touch that, and maybe how long for people to keep their files, especially in the case of children. Bryce, while we're at it, thank you.
So the position in terms of prescription is it's arguable on two grounds. So the baseline position is you've got 3 years in which to pursue a claim, and it's 3 years from which that debt arose. So we would always argue as a defendant, for example, okay, you had the procedure and the intraoperative complication happened on this date. Therefore, that's when the debt arose, and 3 years after that, you must have brought your claim. But it's not always as simple as that. One can argue as a plaintiff, well, yes, I had this intraoperative complication, but I only became aware of the fact that the doctor didn't tell me anything. I suddenly, 2 years later, had an issue, went to another doctor, and that other doctor said to me, hey, you know that you've got this issue.
Yeah.
And there's an explanation. So that the 2 years then doesn't come into play. As soon as the question is, did you have the knowledge required to be aware of the identity of the debtor and the facts giving rise to your claim. So those are the requirements. And as soon as those are met, so in that example of a procedure, you had no idea at the time of the facts giving rise to your claim. They only came 2 years later when you consulted the second doctor. So at that point, you had your knowledge, and at that point, the 3-year period begins to run. And so, yes, in the context of minor children, it's different because the question or prescription is interrupted or delayed by mental incapacity. So if you have a state of permanent mental incapacity, then you are not, perhaps an archaic term is you're a perpetual minor. So you never attain capacity. So yes, you might be 42 years old as an individual with cerebral palsy, but before the law, if your cognitive function is such that you would be considered mentally incapable by law, then your claim wouldn't prescribe. It never becomes prescribed because you aren't capable, don't have capability to appreciate the claim. And so in that context, you can have claims where parents bring it decades and decades after the fact. And the challenge with that is, of course, records are kept, the pediatric and maternity records are kept for the period up until that individual would have attained majority, the normal 18 years plus 2 or 1. And that's the problem. You've now destroyed your records, that period having passed, and 5 years later, after that, the parents bring a claim, or a claim is brought on behalf of an adult person with cerebral palsy, and that's a legitimate claim. The claim hasn't prescribed. What we do often see, though, is the parents will normally claim in their personal and representative capacities. So that means they sue on their own behalf and on behalf of the child with a disability. And the position there is you can say, oh, hang on, you were an adult at the time. You were aware of the fact that there was negligence in dealing with this particular child, this particular labor and delivery.
Yeah.
You should have brought a claim. Your claim in your personal capacity should have been brought within 3 years because you're an adult and there's no interruption on prescription. So yes, your claim on behalf of your child hasn't prescribed, but your claim has prescribed. So you often see that in the context of that type of litigation.
Yeah, I see, Lizzie. Ramya's apologizing. Yeah, sorry, Doc. Saying sorry for all the questions, but we do appreciate them. And when you were referring to the California study, obviously in that environment, I shouldn't say obviously, but a child that is compromised here, life expectancy would most likely be reduced or limited beyond somebody who is living in a first world environment with no other issues. So when you're working out the compensation, you will then take that into consideration, the life expectancy and the implications of what it would take that, right? So you would reduce it, or do you give more because there might be more intensive healthcare that is required for that child?
So we reduce it, or when I say we, the experts fight about this. The life expectancy experts that are involved in dealing with these sorts of questions will often disagree on how much of a reduction there should be at a baseline. So there's certain life expectancy experts that say, there should be a significant reduction for the South African conditions, and there's others that say, no, it's not that much. And you can guess which one's appointed by the plaintiff and which one's appointed by the defendant. So there is across the board, as far as I'm aware, you would see a reduction rather than just a simple application of the Californian life tables. But it's arguable that it should be even more, and we don't really know what the position is, or I don't know that we know what the position is in South Africa accurately. But I'm not a life expectancy expert, and hopefully at some point, you can have someone on who knows more than me and can fill in all those gaps.
We most certainly will. Yeah, Dr. Ramya is just saying here on the side there, I'm not the pastor, but I know the pastor very well. They just seem to be sharing a name here. And also I see Mishka says she can't unmute or put a camera back on. So I think you're going to have an awkward discussion tomorrow at work. Yeah. So yes, and then Vilna Foot, the question is, I told you. So people are asking also in the chat about if this is going to be available for honor as a recording. And so if it is and you're comfortable with it, Bryce, but we normally place our webinars for those that are in attendance on the YouTube platform under the Clinix Health Group banner. So once this has been edited, then what we will do is to place it onto that website and you're able to uh, have that discussion. So what I see, or at least listen to it, as soon as I made that there's a potential threat in your office tomorrow, Mishka came on board. So hi,
That was
Mishka.
just good timing.
There was very good timing. So thank you so much for coming back. We we're almost about to close out, and I'm looking for one of the very difficult questions that are still on the group.
No.
But I think everybody has answered quite an awesome number of questions, and here to answer. So here's a question. Again, gift is coming back at you. This is for you, Mishka. Then we can look at wrapping up. It says, "Hi, Chair. I still would like to know what happens in the case where a court order has been issued to provide specific assistive devices, and the rehab team rehabilitate a patient to some extent that she no longer needs the specific devices as per the court order. Then what happens in that instance?"
So look, I think I might need to jump in there and spare Mishka. Look, it depends on the specific order in the specific case. So at the outset, that's the position. But I think I have an idea of what Gift's getting at. Um, the bottom line is um, you would want to have some flexibility in the order to allow for that type of situation. So it seems to make very little sense um, to have a situation where a particular piece of equipment or medication is prescribed in a court order and strictly speaking should be supplied, but there's no need for it, or that the need changes or shifts. And that's where, as I understand the position from the TN order, the management plan comes into play, with the private and public case managers. But again, each of these cases has had a different order that has been applied differently and interpreted differently. But as just a general comment, I would say you would want to have a mechanism built in that if there's a change in circumstance, you're not stuck with a prescription that makes no sense or in fact could be harmful.
Yes. Bryce and Mishka, thank you for your evening. I hope you're not taking these calls from the office. And if you are, we really want to say thank you very much to Denise and the rest of the directors there in your organization. I'll also have a word with De Niro tomorrow and tell him that you did the organization really proud. And we want to, on behalf of the Clinix Health Group, it is 7:30 at night, and so many of our colleagues are still here on the webinar and on this platform and saying thank you very much. As I told you, this must be for you, Mishka, that everybody is going to continue to be appreciative of the time and the effort in bringing your expertise in this environment. And it is wonderful to see. I consider myself young. I know my hair's changing somewhat, but young people that are in this space, that are expertise, consummate professional in terms of what you do and your ongoing assistance and your availability for what is happening and in the direction that the healthcare system is moving in. So thank you very much for your studious approach to the industry, and I hope you're on our side. For all of us that are on this call, we don't see on the other side. So thank you very much, and for our colleagues, have a wonderful evening. Next week, we'll have Professor Bruce, who will be speaking to us on a matter of ethics. We all need these ethics points, but in terms of what she's going to be talking to us about, it's going to be no doubt engaging and fascinating. May you have a wonderful evening. For those of you that are driving back, please be safe on the road, and we look forward to seeing you next Thursday. Thank you once more, Bryce. Thank you very much, Mishka. May you all have a blessed evening. Thank you so much. Leave all in.